nationwide injunction be made on a case-by-case basis, Professor Bray?
I think it's an excellent question, and equitable decisions from the courts of equity and equitable remedies, including the injunction, do take into account the specifics of the case.
And can't a nationwide injunction case, a case where a nationwide injunction is sought, be handled in that same way, theoretically?
I think it can't be. And the reason is that the argument for a national injunction doesn't really come down to national injunctions in some cases. It's present in every case. And the arguments against a national injunctions, the ones I consider most potent, are also not only present in some cases, they're present in every case. So what you have
largely have to do with its effect on people who are not parties to the case, correct?
Yes, and also...
Isn't it correct, however, that under Rule 24, Federal Rules of Civil Procedure, a non-party has a right to intervene in a case that they are not a party to, that they contend affects them?
Yes, there are traditional devices for bringing in non-parties. Intervention and class actions are ways of doing that.
You can even intervene under Rule 23, under Rule 24 as a class action under Rule 23, correct?
I'm not sure offhand the answer to that question.
What would you say to that, Professor Frost?
My understanding of intervention is that it wouldn't be a method of certifying a class. You'd have to go through the Rule 23 requirements to certify a class.
Certainly an individual who is a representative of a class could file based on the individuality of the interest that he or she is asserting that is affected by the nationwide ban, correct?
Certainly you could try to get a class action and involved or started up in litigation involving a nationwide injunction.
Now, Professor Bray, you contend that the development of the national injunction is, to use your words, an accidental development. Do you mean that the careful and deliberate evolution of case law and precedent and authority based on previous decisions was an accident in the development of the national injunction?
I think it was an accident because it didn't happen through careful and deliberate development of this idea.
Was it a sudden decision?
One of the key decisions in the early 70s, the one that seemed to get the national injunction started, involved a concession by the government defendant that the government defendant shouldn't have made, and so the court didn't really consider the question closely. And so the court said, well, it doesn't really matter whether a class is certified or not. It had all the hallmarks of sloppy reasoning, not careful reasoning.
Was that case appealed?
It was.
And was it appealed to the U.S. Supreme Court?
Either cert was denied or there was no petition for certiorari, but there was not a Supreme Court decision.
And so has there been a Supreme Court decision on the constitutionality of the national injunction? I believe you indicated that there had been some discussion about it in a previous decision that occurred what year?
I think the Frothingham and Mellon decision from the 1920s is inconsistent with the national injunction and rejects it.
Well, I tell you, a lot has changed since 1920, and the evolution of the case law has somewhat kept up with it. Is this issue something that can become ripe at some point for a decision by the U.S. Supreme Court?
It certainly can be, and in
fact... Shouldn't we wait for that to happen as opposed to the legislative branch putting its heavy finger and thumb and entire hand and body on the scales of justice in the development of our case law?
Well, the Constitution binds and demarcates the authority of all three branches. It also binds the court, and it gives to this House the authority to develop rules for the jurisdiction of the federal court. So it is fully within the House's constitutional powers.
I'd like to ask Professor von Spakovsky.
Without objection, the gentleman will have 15 additional seconds.
Thank you. I'd like to ask Professor von Spakovsky what, under Article 1, Section 8, power gives the legislative branch the authority to legislate in this area.
Well, Congressman, there wouldn't be any federal district courts unless you all said there were.
Well, I know that. And
so that
certainly
gives
we have
you
the enumerated powers.
Yeah, I mean, that gives you
set up courts inferior to the U.S.
Right.
Supreme Court. But
the
what other enumerated power under Article 1, Section 8 gives Congress the authority to legislate in this specific area?
Oh, I think the very fact that the lower courts wouldn't exist unless you all said they exist gives you a great deal of authority over shaping what they can do. I mean, part of the problem here is, again, if I can go back to one of the key Supreme Court precedents here on this U.S. v. Mendoza. Look, in that case, the Supreme Court said that a decision in a case in the federal courts isn't going to apply to non-parties to the case. And yet here you have all these federal courts around the country extending these injunctions to non-parties in the case. And part of the problem here, and why I agree with Professor Bray that Congress ought to do something about this, is the Supreme Court is not enforcing the discipline of that precedent.
It's gotten to the point where we're deciding our case law based on who's in the executive branch, and with that, I will yield back.
I thank the gentleman. We now go to the gentleman from Ohio, Mr. Shabbat.
Thank you, Mr. Chair.